Thanks, Cecilia. Lisa, I'm going to studiously avoid the financial incentives for law firms, but given that you act for a variety of organisations defending these sorts of claims in Germany, just focusing on some of the legal issues, I guess, that Cecilia mentioned there, and conscious that we shouldn't dwell too much on non-material damages, but it seems to be that that's quite a big part of what's driving all of this. Can you just sort of remind the audience of what the key sort of requirements are for non-material damages claims in particular?
Sure. So as Cecilia just mentioned, it was particular to some, or it is particular to some jurisdictions to ask for a certain kind of threshold when looking at non-material damages. You need some kind of severeness normally, at least in Germany. And in the Austrian Post case, which we have mentioned before, the ECJ made clear that courts are not allowed to ask for this kind of de minimis threshold. But in the same decision, the ECJ also mentioned that even you can't ask for that threshold, plaintiff still has to demonstrate that the negative consequences he claims to have suffered constitute a non-material damage under Article 82. That means a plaintiff should still have to prove in court that there were actual negative consequences that were caused by the infringement, and that these negative consequences constitute a non-material damage he should be compensated for. When we look at these negative consequences a plaintiff should be compensated for, the ECJ has also made some remarks. And the ECJ stated that plaintiff can rely on a fear that his personal data will be misused by third parties in the future. So he doesn't, the misuse doesn't need to have happened. It's sufficient to have the fear that his data will be misused. But the ECJ also said that if a plaintiff claims this fear, the national court has to verify in each particular case that this fear can be regarded as well-founded. That's again what you've mentioned. The lack of harmonization leaves this to the national courts to determine when something is well-founded. And also looking at loss of control as a non-material damage, the ECJ also emphasized, again in the MediaMarkt Saturn case, that the plaintiff still has to prove of actually having suffered a damage. He claims loss of control, but that's not sufficient. However minimal, he has to show that there is some kind of damage. Otherwise, the mere infringement of the GDPR would automatically lead to a damage, and we've learned that's not sufficient. So, in summary, I think the following quotes from the CJEU put this quite nicely. So, first, it remains the fact that for the applicant in an action for compensation under Article 82 to demonstrate such damages. Secondly, a purely hypothetical risk of misuse by an unauthorized party cannot give rise to compensation. And thirdly, the mere allegation of fear, the mere allegation with no proven consequences, negative consequences, cannot give rise to compensation. So these are quite strict guidelines.